Good afternoon, everyone, and welcome to the first of the three-part commercial litigation webinar. This webinar will address a termination of contract and the duty of honest performance in contracts. While I introduce myself and our speakers, please make reference to the information slide that'll be coming up on your screen that'll give you some of the technical details for today's webinar. My name is Alex Kotkas. I'm in Fasken's Calgary office, and I practice commercial litigation, as do my colleagues. Our first speaker today will be Tom Posyniak. He's an associate in Fasken's Vancouver office in the litigation group, and he's going to be speaking to termination of contracts for breach. The second speaker will be Jennifer McAleer. She's a partner in our Toronto office in the litigation group, and she's going to be speaking to the duty of honest performance in contracts. And our third speaker will be Sébastien Richemont, and he is a partner in our Montreal office in litigation, and he'll be speaking to termination of contracts in Quebec. So with that, also, if you have questions, there is a Q&A option for you, and those questions will be forwarded to me as the moderator. I may have an opportunity to ask some of those questions to the speakers, but probably we won't have time for all of them. And so if you do have questions that arise, please feel free to contact any of the speakers after the webinar, or you can contact myself with any of your questions, but you can also try the Q&A. So with that, we'll get on with our first speaker, which is Tom Posyniak. Thanks, Tom.
Thank you, Alex, and good morning, everyone, and from Vancouver, and good afternoon to the rest of Canada. Today, I want to talk to you about the subject of fundamental breach and repudiation. I want to talk to you basically about three things, the most core concepts in this subject matter. What are they? How do you know that they've happened? And what do you do in response? This particular subject matter can be fraught with difficulty, and keeping it very simple is often one of the most helpful things both internal counsel and even obviously external counsel can do to manage these situations that arise in respect of termination of contract. So the first subject, what are they? So one of the things that I find that's really helpful when you're thinking about repudiation and fundamental breach is just don't get bogged down too far in the terminology, because there's a lot of terminology. You often see words thrown around like anticipatory repudiation, fundamental breach, repudiatory breach, or just plain repudiation. What these are describing at the high level is simply the seriousness of conduct in the context of a contractual relationship and the remedies that are available to you if you happen to be the innocent party on the receiving end of actions that arise to the level of a fundamental breach or a repudiation. In British Columbia, our Court of Appeal has said that there is a subtle distinction, but effectively the repudiation and fundamental breach are tightly related. And if you next slide, please. And doctrinally, in their core sense, repudiation is what, or how I think about it, is when one party to a contract, by words or by actions, just shows they're not going to be bound anymore. They have no intention to complete, no intention to adhere to the terms of the contract. This will often occur at the start of a contractual relationship when somebody has buyer's remorse. One of the common situations we see in British Columbia over the last 3 decades is the real estate context, where a party in an ascending market will refuse to complete on the basis that there's a better offer out there. That is a classic repudiation situation, and usually it simply comes as in the form of I'm not going to complete this contract. Fundamental breach, again, slightly distinct. What we're talking about here is where your time for performance has come or is about to come, your main obligation, and you simply have not met that obligation, and you've substantially deprived the other party of the full benefit of what they bargained for. Again, there's a lot of ways you can phrase that that you see in the case law, going back all the way to the House of Lords and to the Supreme Court of Canada. The point that is that, did you lose what you bargained for? Did you not get what you contract for? And it's simple to state in the abstract, but that's the core concept. And when you're thinking about whether you're in a repudiation situation or a fundamental breach situation, it's important to keep that core concept at the center. Just next slide, please. And again, the remedy is critical here. A fundamental breach, for example, will allow a party to say, I accept what you have done. I accept your breach. I am bringing the contract to an end, and I am suing you for the damages you caused because of my breach. Same thing with repudiation. I accept your repudiation. I'm bringing the contract to an end, and I am going to sue you for what I expected to make on this contract. If they do accept the repudiation, or they bring the contract to an end, the obligations are at an end for both parties, but the innocent party has a claim in damages. Contrast that with a simple breach where all you get is damages, but the contract would still subsist. Classic example, a case I had many years ago. A party tendered performance of basically steel boxes. They provided those steel boxes they were supposed to have rust-proof paint. The rust-proof paint failed immediately. The thought was, well, that we contracted for that, and that was a big part of this contract. But analytically, it didn't rise to the level of, we didn't get what we bargained for. What we got was something less than total performance. We got something deficient that could be remedied with damages or a warranty claim or something to make it better and get what we want. That's the distinction. You would, if you said you fundamentally breached because you gave me rusty boxes, you would probably be arguably wrongfully terminating the contract, and the other side may have a claim. Next slide, please. Before I get into how you know that they happened, and you can see how I've touched on that a little already. One other side note that's a bit, I don't want to say esoteric, but it's actually important. Fundamental breach applies as a general rule of application to contractual relationships for corporations, for individuals, for a number of entities. But interestingly enough, it doesn't actually apply in the usual sense if you're a partnership or a limited partnership as between the partners. So, for example, if you were in a two-person partnership and you accused your co-partner of breaching your partnership agreement, you couldn't bring it to an end automatically by accepting their repudiation. You would have to go through the normal partnership breakup formula. That's just an interesting side note from British Columbia. So how do you know a repudiation or a fundamental breach has happened? Well, repudiation is relatively straightforward. You have to look at the words and actions and assess them objectively to see, have they clearly and unequivocally communicated an intent not to be bound by this contract. In that sense, it's a relatively high threshold. A court is not going to readily infer that. And if you're going to allege somebody's repudiated, it's highly recommended that you have a a solid, dispassionate assessment of what they have done to communicate that. In certain contexts, if you say to your co-partner, I'm concerned you're not performing, I would want you to perform, please tender performance of your end of the bargain, and you're met with silence, that can be a repudiation. If you're called upon to speak and you respond with silence, that can be inferred as repudiation after a certain period of time. Next slide, please. One critical point, because of how the structure of repudiation is focused on the expression, I'm not going to be bound, I don't intend to perform. Things that happen after that don't matter. Just they don't. You can't rebuild, destroy someone's case in repudiation by events ex post facto. Next slide. Now, fundamental breach, I've already kind of discussed about this. The important thing is you assess the conduct, the performance in its total context. You'll see there's a handy list of factors that the Ontario Court of Appeal has published in a number of decisions. What they all amount to, and I won't go through them all, what they amount to is to take the bad performance, for lack of a better word, and say, what in context does this mean for the contract? Does this rise to the level of a breach, bringing the contract to an end? And that requires a deep sense of the facts, which in many cases, if you're in the trenches dealing with this contract, you'll have an intuitive sense of that, and it'll be critical to communicate that deep context to the lawyer if you're seeking outside counsel, and to again focus on the kind of dispassionate context of whether this rises to the level of a total loss of performance in the circumstances. Next slide, please. Now, this is the tricky part. This is where it becomes the situation that's fraught. As the innocent party, you're met with somebody who's done something that's clearly repudiatory. And what I mean by that is they said, I'm not going to do X, Y, Z, which is the essential bargain, or they've tendered performance so bad and so deficient that it's obvious that they've fundamentally breached. You have a decision to make. And this is a decision that requires careful thought, contracts large or small, because the innocent party's in the driver's seat, both factually and legally, in that situation. Again, you have two options. You may accept their repudiation or their fundamental breach, and accept is probably a bit of a misnomer, but I think the focus has to be on what the remedy is. You bringing the contract to an end. You're saying, I'm no longer, you've repudiated. I think that I accept that. I'm bringing the contract to an end, and my obligations are at an end. Your obligations are at an end, except for to pay me damages for your failed performance. The second option is to decline the repudiation. I'm not accepting it. I want you to perform. I insist you perform. Contract is alive for both parties. This is also somewhat risky for you now because you have to tender performance. You're not relieved of your obligations. So option two is as if the contract continues. And if they keep refusing to perform, it's another event of repudiation. Next slide, please. So this election is a tricky time for both clients and their lawyers, but the law has given some flexibility here. There's been a raft of decisions from courts of appeal in British Columbia and Ontario, recognizing that it is a bit of a fraught situation, and you don't have to give a knee-jerk reaction. You don't have to have a hair trigger here and say, make your assessment of the context instantaneous or within the hour or the day or the week of their bad performance or their repudiatory conduct. Your election needs to be made in a reasonable period of time so the parties know their legal position. But a reasonable period of time, it's not precisely judicially defined. It's, again, likely contextual. The underlying concern is that you don't give the impression that you're fine with it by simply being silent. So a party that comes and says, I'm not giving you this house, and flatly states it. If you said nothing for an extended period of time, even past the other events that require performance, you might be taken as affirming the contract without accepting their repudiation, or depending on the circumstances, you might be taken as accepting the repudiation. The point is, silence can have sometimes unexpected consequences. So you need to make a decision, and you need to do it within a reasonable period of time. Within that reasonable period of time, you can get legal advice, you can assess your options, and there's even one Court of Appeal case in British Columbia that says you have the opportunity to engage in without prejudice discussions and to see if you can resolve the situation. And in my experience, sometimes that's an ideal situation to redefine your contractual relationship and get out of this spiral towards litigation. The important thing is to decide if this is serious enough and what you'd like to do next with legal advice. Once you've made an election, you can't take it away. There's no takesy-backsies in fundamental breach. And that's a legal doctrine going back many, many decades. And that's an official term under the doctrine of fundamental breach, I'm sure. It's irrevocable. And that's the end of the election period. Next slide, please. And I think that's the end of me. I'll pass it over to Jennifer.
Thanks, Tom. Before we go to Jennifer, there's been a question asked about back to the beginning of your presentation and the terminology that you referenced. There's been a question asked about material breach and whether that is synonymous with fundamental breach. And my perception of that is that a breach could be material or substantial or significant, but it wouldn't necessarily rise to the point of being fundamental, which sort of takes us into this whole avenue of the courts addressing this question of fundamental breach. But just to stick with the question for the moment, Tom, would you agree that a material breach is not necessarily fundamental, or what's your perspective on that?
Yeah, I agree with that. I think part of the problem is that for decades in Canada, there was this linkage between fundamental breach and the idea of certain contract terms continuing on in existence, an exclusion clause. And so there was an idea that your performance could be so bad as to you can't rely on any waivers or provisions that would protect you from liability and different circumstances. And so the Supreme Court of Canada threw that out, but the language still exists to describe something that brings a contract to an end. And so to answer the question, yeah, a material breach for sure could be a fundamental breach. I was probably a bit too extreme to say that the language shouldn't matter, but the point is, when you're communicating, if you're alleging a fundamental breach, the point is to communicate that you've performed so badly that I have a right to bring the contract to an end and sue you. That's the material part. What you call it, I wouldn't be as concerned about, and certainly a material breach of contract you could characterize as sufficiently fundamental.
in the right circumstances. Yeah,
That's right.
very good. Thanks, Tom. Right, we'll carry on with Jennifer's presentation about the duty of honest performance now. Thank you.
Thank you. Thank you both. So I'm going to talk about the duty of honest performance, but before I do so, I just want to say a few words about drafting notices of default and termination notices. And the message here is really that these should be drafted carefully and that they should not be done in haste. And I think that's in keeping with some of the messaging that Tom just conveyed. Sometimes language does really matter, and we don't want to see people rush into sending out notices of default and in particular termination notices without sitting back and thinking about what is it that they want to accomplish. The election that Tom spoke about, whether or not the contract gives rise to a termination, given the facts that have occurred. Are you going to take the position that the contract has been repudiated? Are you not? Are you simply going to seek damages if the default's not cured? So these are all things that one needs to think about before you send out the notice of default, and ultimately, of course, before you send out any kind of termination notice. So really, it's just a request that people pause, get the advice of in-house counsel if you're fortunate to have in-house counsel, and if not, really our advice would be that these letters be run by external legal counsel before they're sent. Because once they're sent, as Tom indicated, it kind of sets you down a particular route. It can be difficult to claw your way back once you've set out on that route. And the other thing to think about too is try to make sure that you are articulating what has gone wrong, because if you terminate the contract alleging a breach of a particular provision of the contract, and then subsequently it turns out that you were in error, there wasn't a breach, you may have a problem even if there was another section of the contract that was in fact breached, but you didn't articulate that in your termination letter. So the message really is just to be very careful in drafting these and embark in a full legal analysis before you actually send those off. All right, turning now to the duty of honest performance. I'm going to review the trilogy of cases that has come out of the Supreme Court of Canada in the last decade, starting in 2014 with Fasken, and then most recently with the Wastec decision from last year. And I think it might be helpful if we just do a quick refresher of these cases. I'm conscious of the time, so hopefully I'm not going to push through them too quickly. But let's start with the next slide and look at the Fasken decision. So this is a decision that came out in 2014. It was the first time the Supreme Court of Canada articulated this duty of honest performance in contract. And the facts were as follows. Company C marketed education saving plans and had a contract with a retail dealer, which was Fasken. The contract provided for an automatic renewal at the end of the 3-year term, unless the parties gave 6 months written notice to the contrary. Hernew was a competitor of Fasken, and Hernew wanted to capture Fasken's book of business, and Hernew proposed a merger with Fasken, which Fasken refused. Well, the company that was marketing the education savings plans actually wanted this merger to occur and preferred its relationship with Hernew over its relationship with Fasken. And the company, none of this was known to be, by the way, that the company had a preferential relationship with Hernew. So what happened is the company misled Fasken and responded equivocally when Fasken asked whether the proposed merger was a done deal. The company then decided not to renew the dealership agreement with Fasken, and Fasken lost the value of the business. And a lot of its employees and clients went over to Hernew. So what happened is that Fasken sued both the company and also Hernew. Now, keep in mind, there'd been no breach of any explicit term in the contract. The notice had been provided as contemplated by the contract. So the whole issue was whether or not the common law required this new duty of general duty of honesty in contractual performance. And the Supreme Court of Canada found that it did. And the Supreme Court said two things in particular, that good faith contractual performance is a general organizing principle of the common law of contract. And second, there is a common law duty which applies to all contracts to act honestly in the performance of contractual obligations. Now, this duty of honest performance underpins all contractual rights and obligations. It's not an implied term of the contract, it's something larger. It's this organizing principle that underpins all contractual rights. So even if a party complies with the letter of a contract, the letter of the law of the contract, the way it exercises a right or performs an obligation may still result in a breach of the duty of honest performance. So when Fasken was released, it was quite groundbreaking. The lessons that people drew from Fasken at the time were, well, what is good faith? How are we going to articulate that? And the court said that in carrying out performance, a contracting party should have appropriate regard, that was the words of the court, appropriate regard to the legitimate contractual interests of the other party. An appropriate regard for the other party's interests will vary depending on the context of the contractual relationship. All of these cases are very fact-driven. The context really matters. It doesn't require a party to serve the other party's interest in all cases. It merely requires that a party not seek to undermine those interests in bad faith. You can't undermine the bargain that has been negotiated. You have to look to what honesty and reasonableness in performance requires so as to give appropriate consideration to the legitimate interests of both contracting parties under the contract. So in essence, what we learned from Fasken was you have to be honest with each other in relation to the performance of the contractual obligations. Specifically, you must not lie or otherwise knowingly mislead each other about matters directly linked to the performance of the contract or of the termination of the contract. So that was Fasken. Then if we could go to the next slide, the Supreme Court of Canada released the decision in Kellow 6 years later in 2020. Now, Kellow was a situation in which a group of condo corporations had a maintenance agreement with Kellow to provide services. And under that contract, the termination provision provided that the condo corporation, so Baycrest, could terminate the maintenance agreement upon giving just 10 days notice. And this is a termination of convenience. So it was a right of termination under the contract without any cause being alleged. It was simply either party could terminate on 10 days notice. So what happened is that in early 2013, the condo corp Baycrest decided they were going to terminate the contract, but they didn't tell Kellow until the fall of 2013, so several months later. And what happened in the interim is that Kellow continued to have discussions with Baycrest regarding a renewal of the winter maintenance agreement. And following those discussions, Kellow thought that it was likely to get a 2-year renewal of the winter maintenance contract, and that Baycrest was satisfied with its services because Baycrest, the condo corp, had made representations along that line. So during the summer of 2013, Kellow continued to perform work above and beyond what it was required to do under a summer maintenance contract at no charge, because it hoped that this would act as an incentive for Baycrest to renew the winter maintenance agreement. And Baycrest knew that that's what Kellow was doing and why it was doing it. But it at no point communicated to Kellow that it had actually already made a decision to terminate that contract. So in the fall of 2013, Kellow made good on its previous decision, and at that point communicated that it was actually going to be terminating the contract. So again, no breach of the express terms of the contract. The contract only provided for 10 days notice, and that was what was done. So Kellow, the maintenance company, as one can imagine, was not at all pleased with this and alleged that the condo company had withheld information from it and had made misleading statements prior to exercising its right to terminate the contract. And the Supreme Court of Canada agreed. The court found that that the maintenance company was owed a duty to, that Baycrest owed the maintenance company a duty to act honestly in the performance of the contract. And that precludes any kind of active deception, and that the condo company breached its duty by knowingly misleading the maintenance company. Now, what's interesting to note is that the Court of Appeal had a different view. And the Court of Appeal had held that any deception in the communications during the summer of 2013 related to the proposed new contract, not yet in existence, namely the renewal that Kellow was hoping to negotiate, and therefore was not likely linked to the performance of the winter contract. But the Supreme Court of Canada disagreed and overturned the Court of Appeal's decision and found that this duty of honest performance was tied to the termination provision in the original contract. So what are the takeaways from Kellow? So I think, as I made a note, that Thomas said silence can have unexpected consequences. Well, that's exactly what happened here, is that silence, the Supreme Court of Canada found, can constitute dishonesty. And the question of whether a contracting party has knowingly misled its counterparty is going to be highly fact specific. And we know that coming from Fasken, and it's going to depend on the circumstances of the case. So liability will flow if there is any kind of active deception, and that can include silence. If you are of the view that another party has formed a false impression about what's going to happen, and that impression is based in part on your actions, then you may have a duty to speak up. And if you don't, you may be faced with a similar lawsuit. The other thing that came out of Kellow is that because the duty of honesty is imposed as a matter of contractual doctrine, the parties can't contract out of the duty. All right, so then if we could go to the next slide, please. We get to Wastec, which was released in 2021. And what was interesting about Wastec is it talked about how the duty of good faith and the honest performance obligation rests where there's discretion in the contract. So in Wastec, there was a waste removal contract that provided a municipal district with absolute discretion to allocate waste to various disposal facilities. And what happened is the municipal district executed that discretion, and it moved its business away from the party that it had been providing most of its business to. So the issue, in order to assess the claim by Wastec, the court had to determine what constraints the duty to exercise contractual discretion in good faith imposes on the holder of that discretion. And what the court found is that the duty to exercise contractual discretion in good faith requires the parties to exercise their discretion in a manner consistent with the purposes for which it was granted in the contract. So in the terminology of the organizing principle from Fasken, to exercise their discretion reasonably. So the duty to exercise contractual discretion is breached only where the discretion is exercised unreasonably in a manner unconnected to the purposes underlying the discretion. So that was an interesting case because prior to Wastec, people weren't sure what the limits were going to be on a party's right to exercise discretion under a contract. So the lessons from Wastec, I would suggest to you, are you may want to consider setting out in your contract the purpose for which discretion is granted. You may also want to use language to make it clear that this is an absolute discretion and the purpose for which it is being provided. The other thing that was happened in Wastec is that there was extrinsic evidence that was provided to the court. Now, as you may know, extrinsic evidence is sometimes admitted when considering the factual matrix, despite any entire agreement clause in the contract. So you may want to have this in mind when you are negotiating the deal. You may want to articulate the purpose of the discretion provisions that you're putting in your contract, in your negotiations, in your back and forth with the opposing party, so that if you do get into a fight as to what was intended and what was the bargain that was struck and what was everybody's understanding as to why this discretion was being incorporated into the contract, you do have that extrinsic evidence to fall back on if in fact you need it. So in the time that's remaining, let me just touch on some more recent cases that have come out on the duty of honest performance. There are 4 of them that are listed on the slide. I won't get through all of them, but let me tell you about the first one. This is the Princess Gate Hotel case from Ontario. This is a COVID case, and the facts are probably not that hard to imagine. The Princess Gate operated a hotel. And the company, the numbered company, which I'll just refer to as 250, provided food and beverage services to the hotel pursuant to a food and beverage service agreement. The parties also had executed 2 lease agreements for 2 restaurants located in the hotel. Now, 250 had spent millions of dollars on leasehold improvements with the expectation of running the hotel's 2 restaurants. Like many other businesses, however, when COVID hit, the hotel closed to the public in March of 2020. Now, as early as April 1st in 2020, the Princess Gate began engaging in discussions with a potential new food and beverage service provider named Harlow. And Princess Gate actually proceeded to sign a letter of intent with Harlow in June of 2020. Now, the letter of intent provided that it was conditional on the dissolution of both the food and beverage services agreement and the lease agreement that Princess Gate had with 250. Now, 250 wasn't aware that Princess Gate was considering terminating its relationship with 250 and going with a different provider. And 250 continued to carry on business as usual, waiting for the COVID bans to lift so that it could reopen its business. When it was terminated, pursuant to the provisions in the contract, it brought an action against Princess Gate. Now, the finding of the court held that Princess Gate had unlawfully terminated both the food and beverage agreement and the leases. And the court also concluded that Princess Gate had acted in bad faith. And the court emphasized that the fact Princess Gate had carried on a business as usual approach with 250, while at the same time, and unbeknownst to 250, negotiating this contract with Harlow, that in fact resulted in a breach of the duty of honest performance. So the court found that there was no doubt that the hotel undertook the negotiations with Harlow with no intention of advising 250 that it was doing so. It had told its employees not to discuss the negotiations with 250, and at no time did the hotel disabuse 250 of the fact that they would not be returning to the hotel. In fact, the judge described the hotel's actions as bordering on cruel, indicating that 250 was continuing to hire new management staff in accordance with the hotel's demands, and the hotel knew this was happening, yet did not reveal its plans. So the facts are somewhat similar to Kellow in that you have created this misapprehension. You're aware of the fact the other party has relied on your representations, and silence may in fact get you into trouble, and that you're going to have to step up and set the record straight at a certain point in time. All right, the next case that I'll talk about just briefly is the next one on the list here, the Pembina Pipeline Corporation case. That's out of our Ontario Court of Appeal. It's this year. It's also a case where the duty of honest performance was considered. This was a wind farm case. Pembina, or its predecessor company, owned 3 wind farms. And Blue Earth was interested in purchasing all 3 wind farms. However, Greta Energy and another entity had a right of first refusal on 2 of the wind farms. So Pembina announced its intention to sell the wind farms, and it preferred an en bloc sale in its interest in all 3 wind farms. Blue Earth came along and submitted a bid, which was successful, and that resulted in a signed purchase and sale agreement. This triggered the right of first refusal that Greta had with respect to 2 of the wind farms. Now, Greta alleged that Pembina and Blue Earth had conspired to manipulate the price of the wind farms being sold in bad faith in an attempt to prevent them from exercising their right of first refusal. And Greta sought damages for breaching the duty of honest performance, including the breach of contract. The motions judge held that Pembina had set up a legitimate process to sell the wind farms, and Blue Earth had engaged in that process. Further, it was not commercially unreasonable for Blue Earth to pay a price for any or all of the wind farms that would put pressure on the appellants not to exercise the right of first refusal. This decision was appealed to the Court of Appeal, and the appeal was dismissed. So this is a case in which the Ontario Court of Appeal is pushing back a little bit on the duty of honest performance. And the court said that the motion judge did not err in concluding that the respondents did not breach the duty. Pembina had set up a package bidding process on the advice of its bank in an attempt to obtain a better price. The purchase price was allocated among the 3 wind farms only because it was required by the right of first refusal, and there was no evidence that Pembina consciously permitted or encouraged Blue Earth to artificially inflate the price of the wind farm that Greta wanted to purchase. So the lessons taken from this case are, think of the evidence that Pembina would have had to lead with respect to how and why it structured the deal the way that it did. So this tells us that when you're considering putting together a deal or entering into a new contract or terminating a contract, really think about all of that evidence that you may want to put before the court in order to show that you did carry out your obligations with a view to your responsibility to do so honestly, and make sure that you paper your decision-making process so that that is reflected and you can clearly show to the court, if in fact challenged, that you did not exercise any of your decision-making based on bad faith. All right, let's skip the next 2 cases and just go to the last slide. Oh, no, one more I wanted to talk to you about. Actually, if we can go back to the limitation of liability slide, I just want to talk about this really quickly. So, one thing that people have thought about is, well, what if you have a limitation of liability clause in your contract that caps your damages? Can that be relied upon to cap damages for a breach of the duty of honest performance? There hasn't been a lot of case law in this area yet, but there is this one decision coming out of Alberta, which indicates that it cannot. I've given you the quote here from the decision. But basically, it's a public policy argument saying because this duty is an overarching policy, an organizing principle, that you can't contract out of it. And that's also something that we saw in the Kellow decision, this idea that you can't contract out of the duty of honest performance. So if you are drafting a limitation of liability clause and you want to try and do so, my recommendation to you would be that you be as express as you can be, that the limitation of liability clause applies to all breaches in the contract, including any breach of the duty of honest performance. And at least then you can argue that that is the bargain that the parties struck in negotiating and signing the contract. Next clause, please. Next clause, next slide, please. So again, the takeaways are, even if a company complies with the letter of a contract, the way one exercises the right of performance may still give rise to a breach of the duty of honest performance. So don't just look at your contract and the express terms of the contract. You really have to step back and think about what's been going on behind the scenes. What are the impressions that have been created? What are people's reasonable expectations with respect to the bargain that has been struck? And is what you are contemplating or what you're about to do going to run afoul from that? I think that's it. I'll leave it at that, and I will turn it over to Sébastien.
Thank you, Jennifer. So everybody knows that there's some debate whether Quebec is different from the other provinces of Canada. One thing which is not up for debate is that we have a different system of civil law. And my objective today in the 15 minutes that I have is to bring some awareness of the differences that civil law brings to the table when we are talking about contract termination, and also provide you with an overview of what the steps that you will have to go through if there's a termination process that needs to be done. Next slide, please. So when you have an issue of termination with a contract that might have some Quebec component, I would say the first step is to define the legal framework. And what I'm going to try to achieve is to give you a 5-minute crash course in civil law. But it's very important because the first reflex we have as lawyers is to go directly to the contract terms and see what the party have provided for, which is obviously relevant, but there are some steps to be done before that. First, because there are significant, I think, differences, and you'll see from my presentation, and when you compare to what Thomas said on the level of breaches that is required for Terminate, there are some significant differences. So Quebec law can apply for many reasons. Obviously, it could be the choice of law. I often see that in business acquisition contracts from foreigner parties that comes and buy a business in Quebec. The seller will insist on having Quebec law applying, or if the party failed to designate the choice of law, the Quebec private international rules might have an implication that Quebec law is going to apply to a specific contract. So the difference matters. We'll see Quebec law as a codified civil law in the Civil Code of Quebec. And we'll also see that we have different notion of breaches from common law. And for some types of contract, we have Quebec has adopted specific termination rules for specific types of contracts. So once you have decided or ruled whether Quebec laws has applied, then it brings me to my next slide, and you'll have to determine what type of contract you're dealing with. Next slide, please. So in civil law, we have a distinction between what we call nominate contracts and other types of contract, or innominates contract. So you have to find what the deal is about. I'm providing in the slide some example of what nominate contracts are: sale contract, insurance, lease, partnership. Consumer contracts are all type of what we call nominate contract. And then there are the other types of contract that cannot fit in a category. Sometimes nominate contract have their own termination regime. A very good example is the contract for services, and which brings me to the next slide. Contract for enterprise, let's say construction or service contract, have their own termination regime in Quebec, which is that the client may unilaterally resiliate the contract. Resiliate is the equivalent of terminate, even though the work or provision of service is already in progress. So I think you refer to that in common law as termination for convenience. So basic law says you are allowed at any time, for no specific reason whatsoever, to terminate the contract. The code also provides for the remedies. The service provider is entitled in such a termination, but it's very limited, and that's beyond the scope of the subject today. But just keep in mind, it's very important to know what exactly type of contract you're dealing with when you're in a context of termination. So if we go to the next slide now, and then, so Quebec laws applies, you know what type of contract. Obviously, you have to read the contract and to see what the parties have chosen as the termination rules. And obviously, the court will have great deference to what the party have chosen to implement as a termination procedure. That being said, if there is no clear language that tells the reader of the contract that the party's intention was to set aside the general termination rules found in the civil code, the court will still find that the parties wanted to be bound by the general rules. So going back to our example of contract for services, you need, when drafting a contract, if you want to set aside that rule where the client is entitled for convenience to terminate a contract, if you want to set aside that specific rule, you have to have crystal clear language that that's the intention of the parties. If not, the court is going to still allow the client to terminate. So what are the general rules of termination for any types of contract and contract that are not nominate contracts? It's found at 1590 of the Civil Code. So, and I'm talking about breaches situation, as Tom addressed during his presentation. So what our civil code says is that the obligations found in a contract must be performed in full, so completely, properly, and without delay. So if a party fails to perform its obligation without justification, is in default. And then what's the remedy if there's a default? Well, it's up to the injured party to decide what remedy will be asked upon or claim upon. So the party, without prejudice to its right for damages. So setting damages aside, the injured party still have the option to ask for either specific performance of the obligation or resolution or resiliation. I'll explain later what's the difference, but it's basically termination or reduction of its own correlative obligation. So really the client, when there's a breach, has the option to enforce the specific performance or cancel, terminate the contract. And on top of that, it still has the right to claim for damages. So we'll go to the next slide. Also, another element which I think is going to be present during my presentation is good faith. For some of you wonder where the Supreme Court of Canada found those rules of good faith and so on. It's clear that it was inspired by the Civil Code, where since 1994 in civil law, it has been codified that good faith is important at every stages of the contract. So at the negotiation stage, as during the performance and during termination. One thing that needs to be specified and people tend to forget, though, there are some limits to good faith. Good faith does not allow the court to rewrite the contract. So if you have a contract, and we often see that in cases where there's a termination of a contract after a couple of years or non-renewal of a contract, people try to rely on good faith. And even if we would take the Kellow decision example, good faith would not allow you to force upon the other party new terms or a renewal of the contracts or change the deal. That being said, as we've seen in the Supreme Court decision, it's the same in Quebec. It does allow for damages, and it does not also give a rise of an obligation to renegotiate. So the deal is the deal. You have to behave in good faith, but you're not, if you're fine with the business terms, good faith does not impose upon you an obligation to renegotiate with the other side, which is unhappy with the business deal. So let's go to the next slide. So now we have basically the legal framework within which we're going to operate. If there's a breach and there's a notice to be sent, how we should be doing that. I would say on this part, it's not, what I'm going to say is not different from what Jennifer has said. The same concerns are present in civil law. First of all, you have to investigate the breach. Make sure you understand why, what has happened, why it has happened. So really, you have to be able to put the finger on what's the problem. And then also properly identify what remedy you're going to ask for the breach. So as an example, if the breach is a failure to deliver a given product by a given date, what you're going to ask as a remedy is to deliver the product within a reasonable delay, and not ask for all kind of other things that are not part of the contract, or ask for a penalty that are not found in the contract, and so on. Once again, you will always have the option to claim damages on top of anything else, but here we're speaking about failure to perform the contract. So when you're putting the other side on default, you have to tell them you failed to meet with a certain obligation. I'm giving you a delay to correct it. So the notice of breach should be clear, simple, and limited to strictly what's required to cure the breach. And you have to give a reasonable opportunity to cure the breach. Once again, this is still tied to good faith. So if there's a delay given to cure the breach, it has to be a reasonable delay. I have to mention sometime a notice is not required to put somebody in breach. In some cases, the breach is impossible to cure. Let's say you've hired Michael Bublé to come to sing at your Christmas party. If Michael Bublé dies tomorrow, I mean, obviously the contract is not going to be performed, and there's nothing to do that can cure the impossibility to perform the contract. So those are my tips to the notice of breach. Sometimes we're on the other side, we have to respond to the notice. We can go to the next slide. So sometimes there might be justifications for breaches. So obviously that should be part of the response, if any. Force majeure is obviously, and we've all been through COVID, so that's something that has become a hot topic. Once again, if you're intending of raising force majeure to invoke your incapacity to perform, it's probably better to raise it when the situation occurs, not when you receive the notice of breach from the other side. It might look like you're trying to make up for something. The same thing if the other party is also responsible for a breach that has prevented you from performing the contract. Let's say you're to build a house and the other party was to submit to you the sketches of the house and failed to do so. Obviously, you cannot build a house without the sketches. And but once again, if that's the type of thing you want to invoke to excuse your failure to perform, when the other side has failed to deliver the sketches, it's probably better to put them on notice beforehand and not wait until they put you on notice of breaches. Civil law, so, and that's one of the significant difference. We had Thomas has had this question about material breach versus fundamental breach versus simple breach. We don't have those distinctions in civil law. The only thing that cannot be invoked is what we call insignificant breach, or very minor breaches that does not cause any injury or harm to the other party. So the test, or I would say the bar, is much lower to be able to claim termination or claim breach that would lead to termination. If in your response to a notice of breach, you should have a clear and binding language, no wishy-washy answer. You should take a firm commitment to cure the breach within a reasonable delay. So next step, we can go to the next slide. The notice was sent, response was given. Do you move along with the actual termination of the contract? So if a breach has not been cured within reasonable delay, it can be sanctioned by termination. And on top of that, you can claim damages, as I mentioned. Court intervention is typically or generally not needed to proceed with the termination of the contract. But sometimes you have no choice. If, let's say, you want to terminate a contract for sale of a house, which the property has been transferred to the other party and the other party refused to give back the property, then you will have no choice but to go to court to have the ownership title transferred to the initial seller. It needs to be mentioned that a non-warranted termination constitutes a breach as well. So if you terminate without reason a contract, you can find yourself in a breach, which could give remedies to the other parties as well. So the last point to close my presentation is the consequences of termination. So in civil law, we have these two concepts that I've quickly touched upon: resiliation and resolution. So resiliation is basically a termination of a contract for the future. So a contract that has an ongoing obligation. A good example would be a lease contract. So after 1 year of occupation in an office building, there's a breach and you want to terminate the lease. Obviously, you cannot go back in the past, what has happened, but going forward, the office will be returned to the owner and the rent will not need to be paid each month. That being said, once again, the claim for damages remains. So the owner could still go, if there were 4 years remaining on the lease, he could still claim damages in the form of 4 years of rent. Resolution is more applicable when it's a contract, when everything happened, when the contract is executed. Good example is a sale of building contract. So it's still possible to terminate the contract if there's a breach. Let's say it was found out that the building that was sold was full of defects that were not disclosed and not found hidden defects. You could still go for a termination, which we would call in this situation a resolution instead of a resiliation. So what happened then is that you will try to put each party in the same situation they were at the time they signed the contract. So in the case of a sale, the property would be returned to the initial owner and the purchase price would be returned to the buyer. So I've already covered the next point. So on top of that, there's still the possibility to claim damages. Damages in contractual context include loss of gain, so profit that you did not get, as well as any cost that you've incurred as part of the breach or in consequence of the breach. Damage must be direct, and setting aside gross negligence and intentional fault, damage must be foreseeable under civil law. So I hope that in my 18 minutes, I've made you aware that if you have a contract to terminate, which is governed by Quebec law, of a contract to draft that might be governed by Quebec law, there are some specificity to take into consideration, and probably a good idea would be to call upon a Quebec licensed lawyer to help you with this. So thank you, and I'm giving back the presentation to Alex.
Thank you, Sébastien, and thank you to everybody for joining us today, and thank you to the speakers for their preparation and excellent presentations today as well. just a reminder, there is a survey, completing those surveys, it's very brief, but if you complete the survey, it'll help us to improve our webinars as we go forward. So we very much appreciate that. Condolences to those of you who had Michael Bublé to come to your Christmas party. Sounds like it's not going to happen, but we wish him all the best. Our second webinar in this commercial litigation series will be held in early 2023, early next year. So please keep an eye out. Those of you on our list will receive invitation, and if you're not on the list or if you're curious about the date, please visit the Fasken Institute section of our webpage, fasken.com, and you will be kept up to date as we plan and implement the next 2 webinars in this 3-part series. Thanks again, everyone. Have a great afternoon.